Hello, my name is John Snow, and I'm with the law firm of Parsons, Bailey, and Latimer. We have offices in Utah, Nevada, Idaho, and Montana. And one of the things that I do is I do litigation. And as a result, I have some background on the use of discovery responses in connection with a trial or a hearing. And that's what today's presentation is going to entail. It's not always clear how a judge is going to treat a unique use of discovery responses. And sometimes you might be in a situation where you have to come up with a creative way to use a discovery response to get it into evidence, to get it read into evidence or actually introduced into evidence. So having a background on the rules and how they impact the use of discovery responses is going to allow you to have a little more flexibility in how you may get something introduced into evidence. One way is to use the deposition to refresh a witness's recollection or a discovery response and get the testimony or get the substance of the document in that way. But there's various ways to do it, and we're going to speak about that today. Another thing, though, that it's a little bit frustrating is judges don't treat discovery responses uniformly because the rules do not provide specifically how they can or cannot be used. But there is a general reference to the fact that they can be used anyway, as to some discovery responses, any way that is permitted by the rules of evidence. So how do you get it in? Well, if the rules of evidence allow it or don't exclude it, you're going to be able or should be able to get the evidence into, get the document or the discovery responses into evidence in some way. In some instances, it's merely read into evidence. In some, it could be part of a pretrial order or have the judge read it or you read it to the witness while they're on the stand for the jury's benefit. But there's lots of different ways and techniques for this, and we're going to talk about some of that today. I'm going to provide some suggestions for consideration on how to use discovery responses, but again, it's dependent on the rule, the circumstances, and the judge on how you get it into evidence. The first discovery response, as the most widely used, of course, is the deposition. Through my years of practice, I have found that I've gotten really, really helpful testimony in a deposition and yet been unable to use it because the question that preceded the answer was too confusing to make the answer clear. Now, I remember the deposition, so I remember what I was trying to do, and I remember the witness's response, but when you read it in black and white, it just doesn't come out the way I believed it to have been, how I believe it to have occurred at the time of the deposition. And it's because there might be a pause in a question, or you might start a question over. And so you have a combined question. You're not sure what answer is, what question is being answered by the deponent's testimony. So even though this is not a seminar on how to take an effective deposition, it's on the use of a deposition, but fundamentally, you have to take a good deposition before it is going to be useful at trial. And whether you're taking the deposition for discovery purposes, impeachment purposes, limitation on testimony purposes, or just substantive responses, you want to have the answers clear. Otherwise, you're really never sure what you got by way of an answer in a deposition. So make your questions simple. Make your questions easy to understand. Ask for the narrative because you want to hear what they have to say, but then take their narrative and break it down into parts. So when they give you a narrative and some of it's helpful and some of it is not, go back and isolate the portions of the narrative that were helpful. It's also helpful when you're taking a deposition to clearly identify the exhibit. And you can refer to it as Exhibit 3 or Exhibit 4 or whatever number it happens to be. But when you're reading a transcript, it's not as effective with the jury to have to refer to an exhibit than explain the exhibit. It's better, in my view, if you simply say, I'm going to show you the letter, the June 12th letter we've been talking about. and to identify it from time to time as whatever exhibit identification it is, and then ask the witness the question. That way, when you are reading the transcript to the witness for the jury's benefit, it is clear, it is self-sustaining. You have a question and you have an answer. And you have a clear question and you have a clear answer. You have clear reference to a deposition, which may not be the same exhibit number at trial. And therefore, by identifying it by name, you have a clear standalone answer with identification of an exhibit that the jury will understand.